Hi, it's Mike DelSignore. In today's video, I want to talk about what happens if you're charged with domestic assault and battery, and the case is going to be heard in the Concord District Court. So when you're charged with domestic assault and battery, everyone wants to know one thing: how quickly can you get the case resolved? In most cases, your wife, your girlfriend, is not on board with the case. They didn't want to see you get arrested. So typically, the situation is there was some incident. Often it involves drinking. There might have been an argument. It's certainly common. Something comes up on somebody's phone, messages, things like that. So you have a minor argument. The police are called. And when the police are called, then someone alleges there was some physical touching, and the police make an arrest. After the arrest, the person that is the so-called victim wants the charges dismissed. You'll receive a court date to appear in court on the next date. And if it happens within one of the courts within Concord District Court, that's where you'll appear. You'll appear in the first session. You'll check in with probation, and then you'll be arraigned. So now at the arraignment, this is where you're formally notified of the charges. But unlike what most people expect to see happen, most people think you're going to go in, you're going to talk to the DA, explain that it was a misunderstanding, the case is going to get dismissed. That's not how these cases work, unfortunately. The case will then be put on for a pretrial hearing and eventually a trial. And at the bench trial stage, which is months down the road, and I like to make sure everyone has all the accurate information about cases. I never make the case seem worse or better than it is. So yeah, this is months down the road, maybe as few as 3, 4, but there is some time. The case would get dismissed at a bench trial date if the government cannot go forward with the case. So why could the government? So let's say the victim's not on board. Let's say that you're married to the person and they can assert their marital privilege. They're not available as a witness. So there's 3 situations where maybe that's not going to end the case, where despite the fact that the victim's not on board, the government can still proceed. First situation, something I had in court today. Let's say you're charged with strangulation and there was a dangerousness hearing. Now, if your wife or your girlfriend, spouse testified at that dangerousness hearing and testified about what happened, potentially that can come into evidence. Now, that's a sort of an uncommon situation, but if there's a strangulation charge, often there's a dangerousness hearing. And if there's any preserved testimony, that could be used. The more common way is a 911. So your wife, your spouse, your girlfriend, family member, they call 911 and they say, for example, hey, my husband just hit me. Can you get somebody over here? He's out of control. He's drunk. That statement, sort of in the heat of the moment, is considered what they call a spontaneous utterance. So it can come into evidence, and it can come into evidence even if the person doesn't testify. Now, normally, if someone doesn't testify, their statement can't be used in court because you have a right to confront witnesses against you. But in this area of law, that statement can come in because the courts have said, and this is from the highest court in the United States, the United States Supreme Court, is that the person making the 911 call, their primary purpose is to get help, not to accuse you of crime. Now, I don't agree with that logic. I think it's result-oriented, and these cases are very closely decided, even at the United States Supreme Court level. A swing of one justice here or there can change the outcome, but that's the law as it stands now. We can always challenge that, saying this primary purpose test really was never consistent with the confrontation clause, but that's the theory that it can come in to evidence. Now, DAs don't always proceed on this theory. Usually if the person's not on board, if you don't have a record, a lot of times they're not going to be that aggressive and they're not going to pursue this 911 theory of trying to prove the case without the victim. But there is a way they can do that. So the 911 call is key. It's something we'll want to look at and listen to see if there's a viable path for prosecution. The other avenue is if there's an independent witness. Now, if it's your children, usually they wouldn't call children. Now, they can, but they typically don't. So an independent witness might be a family member. If it's out in public, they could certainly call, bystanders who may have seen what occurred. So you have 911 call, independent witness, and prior testimony. Really the 3 ways that a domestic assault and battery may not get dismissed, even if the victim is not on board with the case. So if you're charged with domestic assault and battery in Concord, feel free to call me. My name is Michael DelSignore. I handle cases there in all over Massachusetts, everywhere I understand the law, be able to help guide you through the process and make sure that it's resolved as quickly as possible. that you understand what's going to happen every step of the way. My number is 781-686-5924. Feel free to call, text. It's never too early, too late to call. I'm here to help.